Welcome, ma'am. Thank you very much for good wishes.
तीन रोड को करके एक रिपोर्ट करते
ठीक है।
रिपोर्ट मीटिंग पे
अच्छा उसमें जाकर कीरों में जाकर
Good morning, sir. Good morning, sir. Uday Shankar, sir. Our keynote speaker is with us, Professor Uday Shankar from Hidayatullah National University.
Everyone.
Good morning, sir.
Good morning, sir.
Very good morning, sir.
हेलो
Pawan, sir, we'll wait for 5 minutes for participants to join, I think.
No issue, ma'am.
Professor Devinder Singh has joined us. He's the chief guest for the event. We welcome you, sir.
जी मैडम नमस्ते. Thank you very much.
Namaskar, sir. Namaskar.
Thank you.
Good morning, Pawan, sir.
Good morning, ma'am.
Our chief guest and the keynote speaker are already with us, so I think we will start. Rajesh ma'am. A very good morning to one and all present here. The liberties of none are safe unless the liberties of all are protected. This quote of William Douglas is self-explanatory. A very warm and cheerful morning to one and all present here. I, Dr. Alka Bharti, coordinator of the event, welcome you all to the one-day online national seminar on the theme Civil Liberties in Parliamentary Democracy, Recent Issues and Challenges for India. I am your moderator for today's session, and I'm so overwhelmed to share that we have a massive response for the event from all over India, and I'm delighted to inform you that we have more than 100 registration and participations across the country on various sub-themes. I want to assure my fellow participants that the sessions are going to be very productive and enlightening with our distinguished speakers. In this sequence, we have Professor Devinder Singh, Chairperson, Department of Laws, Punjab University, Chandigarh, as our chief guest for the day. We extend our heartiest welcome to Professor Devinder Singh. Professor Uday Shankar, Registrar, Hidayatullah National Law University, is our keynote speaker for the day. We welcome you, sir, to the forum. As far as the schedule of the seminar is concerned, we are going to have 4 technical sessions, and the resource person for the first technical session is Dr. Deepak Kumar Srivastava, Associate Professor, Hidayatullah National Law University, Raipur. We welcome Dr. Deepak. For the second technical session, we have Dr. Nasima PK. She's Assistant Professor in Law, AMU, Mallapuram Center, Kerala. We welcome you to the forum, ma'am. We extend our heartiest welcome to Dr. Manjinder Guliani, Senior Faculty Member, Institute of Law, Kurukshetra University, Kurukshetra, as our resource person for the third technical session. And the resource person for the fourth technical session is Dr. Jaswant Saini, Associate Professor, Department of Law, Maharshi Dayananda University, Rohtak. We welcome you, sir. And we also have Dr. Dipali Mathur in that session. We welcome you, ma'am. This seminar aims to have some meaningful deliberations aligned to the theme of civil liberties. It's high time to realize the sanctity of the fundamental aspects of liberty, justice, equality, and fraternity as enshrined in our sacrosanct constitution. This can certainly pave the way for egalitarian pattern of society, and this seminar is a humble endeavor to achieve that end. And I sincerely hope that we are going to have some wonderful deliberations on this platform today. Now I again welcome you all, and I would like to welcome Dr. Pawan Kumar, coordinator of the event, for the concept note. Over to you, sir. Pawan, sir.
Thank you, ma'am. I express my sincere gratitude to the university and the department for providing this opportunity to lay down this concept net for the seminar, although it was circulated at the time of the when we conceived this particular seminar at that time. And firstly, I welcome the chief guest of the occasion, Chairperson Professor Devinder Singh, Chairperson Department of Laws, Punjab University, Chandigarh, as well as our keynote speaker, Professor Uday Shankar, Registrar HNLU, Raipur, and all other resources chairpersons, deans, and faculty members of this particular university and from various universities who are going to present their paper. We are looking forward for a deliberations, as we are all know that the mother of all democracy, what we can say, the all parliaments, what we call the Parliament of UK, the Britain, we say that that is the mother of all parliament, and it has set a trend. Although there has been what Winston Churchill told in its parliament when we got independence in 1947, that look, the democracy is not the best form of government, but it is better than all worst form of government. So we hope we will be discussing that how the representatives of various democracies, and especially we being the largest democracy in the world, how we are setting trends for the world. So that and today in a crisis when the civil liberties of sections of a particular country, they are in peril, so it is more relevant to discuss for the that it's a challenge for everyone, and India cannot be a mute spectator to such happenings. Although what we have told till date, it's not many countries they are expecting from India that they should play a better role than what they are playing today. Although I am not going to that, we are looking forward what we are supposed to deliberate today. And we are supposed to deliberate because why we thought about this seminar, let me tell you. In, in 2021, there was a report by the international idea, what I say, International Institute for Democracy and Electoral Assistance at Stockholm. They have come out with a report that there are certain democracies which are free, there are certain democracies which are sliding in their ranks for the reasons that there is the civil liberties, especially the right to life, which includes, which I will deliberate that what are the components of that. The report has come that India is among the sliding democracies, and which is a matter of concerns for everyone. And that is why we thought that whether that particular report, which has come at international arena and which has attracted the attention of the world, is really true. Because what I see that in India, one particular sections of a society, in its very heart, what we say the capital, they has been agitating, protesting for almost 1.5 years, and they blocked the roads also, and they somehow no force was used, although there must have been some tactics by the government. So what we are willing to deliberate, or what we are looking for the deliberation, what is our concept, is the how far Indian Parliament has been successful in protecting the civil liberties of its citizen as well as non-citizen, those who are visiting this vast land, right? Because what we promised in 1949 when we adopted and gave ourselves a liberal constitution, certain ideas and values, they were enshrined there, they were, and we are looking how far we have traveled, because 73rd Republic Day we have just celebrated. So how far we have championed those values and ideas, and what are the challenges in today's scenario, because it has been stated sometime that majoritarian governments at one point of time, it has been stated in parliament that majoritarians uh, parties in parliament, they fail somehow to keep the or protect the interest of the minorities. So that is also one of the concerns which will be deliberated, because we are all aware that the parliament was assigned the responsibility to ensure the dignity and the fundamental rights of individuals when we established the representative democracy through parliament in under our constitution, and to achieve the social justice as well as to foster economic and social development where everyone will be enjoying the fruits of development, strengthening the cohesion of the society, and enhancing fraternity. That is what our preamble is also. We have talked about the ensuring the liberty of the individuals as well as the justice, three kinds of justices, right? And fraternity and unity, all we have talked about. And all these values which have come, because what is desired? Desire is that the people, they should frankly, openly, in a non-discriminatory manner, they should participate in the affairs, public affairs, and the institutions, the public authorities which has been established by the constitution, how these public authorities they are behaving, whether they are sensible to their duties or there has been fallen values. So we are supposed to deliberate on that. And especially we have to see that how many times how the opposition has been treated, how the minorities group has been treated, how the students have been treated in universities, because there has been in recent times, you will see last 3 4 years we have seen the university students facing sedition charges for expressing their opinions. And what has happened, police has not been able, because we see the agencies being misused by the parties in power. We would not say even today's party, it has been during previous governments also, there has been allegations. Our highest court has come out with observations that how the agencies they are not independent, especially law enforcement agencies. And there was a talk about CBI also, although we had come out with the CVC Act, we have come out with the lockballs. So how effective those institutions have been in protecting the core values which we undertook in 1949. Also, it is that how people have been able to assess those public authorities, as well as the activists, and how they have been able to petition the government, what has been the behavior of the courts, those who have been given the duty of protecting these civil liberties, because we know that the most cherished civil liberty is the right to life. And we know that how our constitution framers they guided in article 21 that because there was a deliberations between the constitutional advisor and the framers of the American constitution, that whether India should have a due process of law or procedure established by law. There was a deliberation on that. And ultimately, we went for the procedure established by law, and how that procedure established by law has taken shape of the due process of law when the courts have come out that a law must be just, reasonable, and fair. And we cannot forget that India has some golden moments when it saw justice like H.R. Khanna, who laid down in clear and explicit terms that look, right to life, even if there is no provision in the constitution, even then there is a natural right, and that people cannot be deprived of that right, unless and until there are certain compelling reasons, right, in the interest of the nations, what we see. And what we see during last 73 years, we have seen that this right to life, it is from the phenomena that personal liberty, it has not been only personal liberty, it has gone beyond it. What has come, we have seen that how telephone tapping case, how court has come out that there is a need to secure the privacy of the individuals that is inherent in this right. How we have come to know that right of freedom of speech and expressions, how the Supreme Court has come to the rescue of the people for democratic, showing the concerns in 2003 that there is a criminalization of politics in India, and the voters need to know antecedents of the candidates, right? And at the same time, we find when recently the Prime Minister of Singapore, he has how he highlighted the dangers to the parliamentary democracy in India, that almost 43% of the parliamentarians they are facing charges, serious charges of violating its own criminal law. So these are the, I hope, some grave areas where we will be looking. At the same time, we find that how the environment has become a threat to some portions of this country during a particular season, which has threatened the life itself, and the people has to inhale such gases, which has resulted and which has threatened their organs, vital organs. So that is also, I hope there will be deliberation on that. At the same time, there has been about equality. When we talk about equality, there was a saying that look, it has to be taken like we says that it cannot be creamed, grabbed, or imprisoned. In it doesn't belong to the era of king. It's a republic where everyone has to be treated in a fair manner. There cannot be arbitrary decisions. You can't restrict the life of someone. At one point of time, when it was stated that these all freedoms under Article 14 equality or 19 or Article 21. They are separate in components. Their approach, it was taken that every article is exclusive in itself. But later on, this approach, which started at, we saw the expansion from Menka Gandhi versus Union of India, that how these rights have moved beyond it. And we saw in recent years that how a law, criminal law, which penalizes the homosexuality or the curbs the rights of a particular gender, third gender group, how it has been recognized. And we have seen that how the peoples who doesn't believe in a particular religion or particular thought, even they have been given protection by the law. But at the same time, there has been a matter of concerns like Pegasus. There has been allegations by the oppositions that electoral process is not fair in India, although we have been witnessing regular elections in 73 years. But at the same time, why we are we can say that there is a backward sliding what the international idea organization has come out, that one of the reasons is that the treatment of the minorities, rights of the activists, and the third one is the electoral process, that the electoral process, it has not been clean, that there has been allegations of rigging, although not at large scale. We didn't find that much substance. The opposition has gone up to the extent of saying that there is a rigging with the electronics machines or EVMs, right? Although we did not find any substantial proof. We have a election commission of India which has been constituted, established under the constitutions, and it has been fairly praised. And one of the election commissioners, uh, Commissioner Dr. Qureshi, he has categorically told in that report that there may be some backsliding, but at the same time, the democratic values, they are inherent in Indian citizens, and that is quite sound. And citizens are willing to defend those, right? And the universities are supposed to be the flag bearers of all these ideas, these values, and the principles. So I hope that will be discussed within Parliament. Also, there has been allegations by the oppositions, by the government, violations by each other. How many times marshal need to be called in the Parliament? How we have seen that how parliamentarians have behaved in the Parliament. The reasons I have already told, that those people who are facing such serious, some of them serious charges and some of serious accusations. When there are such serious charges and accusations, these scenes are likely, but at the same time, they are a threat. And what I saw in the recent elections, that the speech of the very high officials, it has gone down to a still, it has gone to worst level, I would say, when they are calling the parties that they are sponsoring terrorists, or someone is alleging one thing, another is alleging one thing. It is not sending a good message to the polity, and it is a matter of concerns. I hope there will be deliberations on all those issues, that how our political leaders, they need to behave, and what is the role of the money in the elections, whether there is a transparency in that money, and what is the mechanism, what kind of electoral reforms are required, because we are all aware that in 2003, when this criminal antecedents case came, how Parliament united, how these legislators, they united to bring a legislation that in spite of a constitutional mandate or judgment by the apex court, that they will not be bound. And at the same time, we find that the political parties which are in power and which has been in power in opposition today, none of them is willing to disclose their source of income or expenditures which are spent during the elections. So that is another concerns area. I hope this conference, the participants, they will deliberate over that also. At the same time, when we have come to know how a renowned scientist was deprived of his personal liberty by the agencies, enforcement agencies, by the police of a particular state, and how we lost a particular talent for such a period of time. So these are the grave areas, I hope, on which we all will deliberate. There has been serious deliberations on the freedom of religion also in India, that whether there is a freedom, whether every religion has been treated equally, right? And although there has been what we can say that people by and large, but at the same time, there has been, India has what I see, communal violence we have seen from time to time. Even in Haryana, we saw it in 2016. There has been in Gujarat, right? And it has been in Bhagalpur also. So none of the political parties is free from that accusation, right? They are instigating such an elements, and we, as a nation, have shown concerns from time to time. And I hope all the academicians, and I look forward especially to our keynote speaker. When I met Professor Devinder Singh in 2005 in one of the conference at Regional Center of that Amritsar University. So we hope to listen from him as well as the keynote speaker. With these words, although there has been, like on privacy also, like on what we say, that on the in free business also, there has been issues like federal issues. The government, they have been accusing the union government that, look, you are weakening the federal structure. Whether that weakening of the federal structure will be good for our civil liberties, or it will have some grave consequences. So I hope all these issues we will deliberate. Thank you.
Thank you, Dr. Pawan, for such a thought-provoking concept note. Now, I would like to invite Dr. Rajesh Hooda, in charge Department of Laws and Director of the seminar, for formal welcome address. Over to you, ma'am, Rajesh ma'am.
Thank you, Dr. Alka. Before I proceed with the welcome note, I would say thanks to Dr. Pawan Kumar for a very thought-provoking concept note. And I think this is such a vast concept note that all the participants are feeling motivated, and curiosity I could see in the participants, and much of the questions which poses a big concern for all of us and for the academic fraternity, and as well as for the whole nations he has well laid down. Thank you so much, sir. Very warm greetings to one and all present here. I am Dr. Rajesh Hooda, Chairperson of Department of Law. On behalf of the organizing committee and the Department of Laws, I welcome all the participants, dignitaries, deans, chairperson, and our guests and speakers present with us in the National Seminar on Civil Liberties in Parliamentary Democracy, Issues and Challenges before India. The theme of the seminar, Civil Liberties, as much important as our environment mean to us. I see our environment safe and free only when an individual and the people could enjoy the liberties and the choices they should have as a human being. Environment, a pollution-free environment is important for all of us, just like water and air. But air, water, and land are not the only component of the environment. Civil liberties are the integral part of it and complements any healthy surroundings which an individual need. Water and air is the life of any creature, but civil liberties are the fundamental feature and evidence of any civic society, egalitarian society, and its democratic setup. Civic society assures and guarantees to its people liberties to breathe out their thoughts freely, and people can inhale the notions, beliefs, either they are religious or the political, but they must have a choice. And of course, freedoms are never absolute and always have a rider. Social, political, and legal institutions are for the freedoms and liberties, and to evolve a mechanism to make reasonable restrictions and which must be justifiable too. Civil liberties are indispensable and primarily must render our society to make it cultured and more refined in passage of time. Civil liberties has always been credentials in all ages and all political systems. Emphasis is on civil liberties because people cannot be allowed and our social legal system doesn't allow, and in fact cannot allow, and it must not and never allow the criminal liberties. So that's how we need to perceive and develop a sense of freedoms and civil liberties that previously Dr. Pawan in his concept note discussed. Discussion over such a theme and topic is always viable and warranted, irrespective of time and phases. Few years back, I imagined and perceived civil liberties in a different pain. Now, with time and transformation of the society developments, I comprehend and contemplate these in a different connotations and perspectives. The dimensions and expansion in the civil liberties contemplate with the developments of the human rights perspectives, and that's what I perceive as a scholar of the human rights field, that civil liberties are not different from the human rights. जो भी मानदंड हैं, जो भी मापदंड हैं, चाहे इनका जो भी स्वरूप हो, चाहे जिस भी परिप्रेक्ष्य में हम इनको देखते हैं, समय के साथ सिविल लिबर्टीज में भी एक्सपेंशन हमने देखने को मिला है। और जो लॉ स्कॉलर्स हैं, जो लॉ से जुड़े हैं, वो जानते हैं कि आर्टिकल जो 21 ऑफ द कॉन्स्टिट्यूशन है और जो ह्यूमन राइट्स है, इसका भी जो एक्सपेंशन विद टाइम हुआ है, तो उसके साथ साथ सिविल लिबर्टीज को लेके भी जो हमारा परिप्रेक्ष्य, जो इनका स्वरूप है, वो भी लगातार बदल रहा है। बट सिविल लिबर्टीज आर वेरी इंपॉर्टेंट इन ह्यूमन लाइफ, एंड दीज आर ऑल्सो इम्पोर्टेंट to establish the democratic setup which should never be diminished and demeaned at any cost. Civil liberties build the base, and they are in fact the building blocks of any successful democracy, and disregard any kind of disrespect to these may deteriorate the human values and the principles. This is against the human rights. मानव संवेदनाओं, मूल्यों व व्यक्तित्व के साथ साथ सुदृढ़ समाज का प्रतिबिंब हम सिविल लिबर्टीज में देखते हैं, एंड वी कैन नॉट प्रोग्रेस विदाउट assuring these. Right to speech and expression is a civil liberty. But with this, I see that freedom of speech can never be enjoyed without assuring the safety of the speaker who is expressing. So there are certain aspects which we need to look beyond the basic civil liberties which are enshrined in the Constitution. In today's complex world, we need to deliberate on, think on, and all such issues with the changing facets and dimensions. What civil liberties mean to us, and which civil liberties are included in it. All these is point of discussion and concern today. Besides, there is more complex situations and intricacies coming to our way in daily life regarding our freedoms, और जिनके बारे में सोच व नजरिया बदलने की भी जरूरत है और डेवलप करने की भी जरूरत है. The theme of the seminar is not so common, which I could see everywhere in our surroundings, in academic fraternities, but it's very, very important. All the questions, doubts, ideas, and perceptions on the topic, I hope and I am sure will be addressed today. I feel honored to receive and welcome our renowned and eminent keynote speaker and the chief guest, Professor Uday Shankar ji and Professor Devinder Singh ji, for their expert and in-depth visionary talk on the topic. I very cordially welcome you, sir. It's an honor for the Department of Law, faculty, and for me to get this opportunity to organize this event, and I am grateful to all for joining us in this discussion. I take this opportunity to introduce you to our dignitaries, keynote speaker, our chief guest, and all the resource person who are with us to participate in this deliberation. Professor Rajendra Kumar Anayaji is the Honorable Vice Chancellor of our university, and he is also the Vice Chancellor second time of the D. Crust Murthal. I would like to extend my greetings and regard to him, though he is not personally present for some parallel and very important assignment, but his motivations and administrative supports has made this program and helped us to organize this event. Dr. Neelam Malikji is the registrar of our university and he is in the administration for last 15 years. She is working tirelessly for the university. I welcome Madam Neelam Malik and simultaneously I thank her for her unconditional support. I would like to welcome and introduce you to the chief guest of the seminar, Professor Davinder Singh Ji, who is the chairperson of the Department of Law, Punjab University, Chandigarh. Our pleasure and proud to welcome him as he is a great scholar and academician. Professor Devinder Singh Ji has a vast academic and professional experience. He has worked on a project titled Acceptance of the Runaway Couples by Their Family and Society, a socio-legal study. And he has also supervised various PhD scholars and dissertations. His contribution in publication field is very tremendous and huge. He has authored more than 54 articles, books, and he has contributed in the field by editing the books also. He has got more than 33 papers published in different journals of national and international repute. He has been invited as the chief guest and guest of honor at several occasions in the various programs. He was the guest of honor in third National Moot Court competition, and he was also invited as the chief guest in the ICSSR sponsored national seminar on crime, society, and state, Riot College of Law. He has been the referee and member of the editorial boards at various reputed institutes. Uh, he has been the referee of Punjabi University Law Journal, Punjabi University Patiala from 2014 to 17. He has been a reviewer with the publisher Routledge, Taylor and Francis Books India Private Limited for a book on biodiversity and sustainable development. He has also been a referee to a law journal of the university with an ISSN number. He has also been a member of the editorial board of the book titled Relation in Working of Literature. We having a detailed look on his profile, we find it would not be possible to cover all his academic and professional contributions here, but it is matter of honor to have him as our keynote speaker. Welcome you, sir. I also extend our warm welcome to our keynote speaker, Professor Uday Shankarji, who is the registrar of Hidayatullah National Law University, Raipur. And it is a matter of great pleasure to have you, sir, among us. He is very dynamic and versatile personality with enormous academic and professional contribution. A very cordial welcome you, sir. On behalf of all the organizing committee, I convey my hearty welcome you, sir. I also welcome our resource person and chairpersons in the technical sessions, Dr. Deepak Kumar Shirvashtaru, Associate Professor, Hidayatullah National Law University, Raipur, Dr. Naseema PK, AMU Center se wo hain, Mallapuram, Kerala. Another resource person and chairperson, Dr. Manjinder Guliani ji. She is from Institute of Law of Kurukshetra University, Kurukshetra. And Dr. Jaswant Saini ji from MDU Rohtak, and Madam Dipali Mathur. She is our colleague from Department of Social Work from BPS.MAHILA. KHANPUR. I welcome all of you. I also cordially welcome our Dean, Professor Vijay Nehra ji, Professor Dadir ji, Dr. Ravi Bhushan ji, and all my faculty, friends, and participants. Welcome you all and hope this is going to be wonderful and worth your precious times and contribution. With all the good wishes, thank you. Over to you, Dr. Alka.
Thank you so much, ma'am. I would like to inform the forum that our Honorable Vice Chancellor, Professor R.K. Nayaji, was very keen to join us today, but due to some prior official commitment, he was not able to make it. But he has conveyed his regard to the dignitaries on the forum and best wishes for the participants. He's the real pillar of strength for our academic endeavors. He's very instrumental in motivating us to conduct such learning interface. We are very grateful to him for his kind cooperation and support. Now, Professor Uday Shankar, Registrar, Hidayatullah National Law University, is our keynote speaker for the day. He has the teaching and research experience of more than 19 years in the field of law. He has served as a guest professor under Magdalene Scotch Fellowship, and he has served as a guest professor under the same scholarship awarded by the Faculty of Law, University of Hamburg in the year 2016. And he is also the recipient of the prestigious fellowship from the Max Planck Institute of Comparative Public Law and International Law, Heidelberg, in the year 2008. He is a member of International Association of Constitutional Law. He is also the lifetime member of the Indian Law Institute, Delhi. He has more than 50 academic writings in journals and books to his credit. He has presented papers and delivered invited talks in more than 70 conferences in India and abroad. His papers and delivered his course on Introduction to Law on Electricity is offered under the scheme of National Program on Technology Enhanced Learning project funded by Ministry of Education, Government of India. He has organized Gyan courses on energy law and policy and short-term courses on labor law and Make in India and Skill India. He is also on panel on various editorial boards and advisory boards in national law universities and other law colleges across India. Further, he is also a director of the Global Network of Human Rights and Environment. He is also the leading ambassador program of Max Planck Alumni Association. So we welcome you to the forum, sir. And now, without wasting much time, I invite Professor Uday Shankar, our keynote speaker for the day, for the keynote address. Over to you, sir.
Thank you, Madam Madam Alka Power. Thanks for this generous introduction. Good morning to distinguished dignitaries and the other participants. I express my thanks to Professor Pawan Kumar, the coordinator of the seminar, for giving a background and also very lucidly explaining the context in which this seminar was conceived. My thanks to also Dr. Mrs. Rajesh Sudda, in charge Department of Laws, and the co-speaker in this seminar with me, Professor Devendra Singhji, Chairperson, Department of Laws. And also thank to Professor Alka Bharti, who has been coordinating with me, I believe, for last a month or so, I would say. Sometime I have been responding very promptly, sometime it is with delay. Kindly excuse me for the same. The topic appears to be very interesting to me for two reasons, I would say. One, should we look at parliamentary democracy as a tool to promote civil liberty, or as mentioned by Professor Pawan, that when it is to be seen as a tool, whether there are deviations happening and because of which the idea of civil liberty is getting compromised. The other way of looking at it is this, that parliamentary democracy necessarily supposed to address, necessarily supposed to promote civil liberty. And I will prefer to focus my discussion on this second aspect. when I look at the Constitution of India, I truly acknowledge the kind of innovativeness introduced by the framers of the Constitution. And one such innovative experiment to me is, there are many, and I mean, one which relates to this theme of the seminar is bringing in fundamental rights and directive principles as sort of collective goal for ensuring the realization of human rights. They have very nicely presented this structure where all the three institutions were being assigned the role, all the three institutions of the state. Look at the fundamental rights. Judiciary has a defined role in ensuring the protection of rights. In fact, literature indicates that Article 32 is a very distinct right and very singular, which you would not find in even progressive constitutions of the world, where right to get constitutional remedy itself is a fundamental right. So the role of judiciary is being envisaged. And also, very prominently, the role of legislature and executive is being spelled out for doing all what is needed to give effect to directive principles. And that's how I see the connection with this today's seminar, civil liberties in parliamentary democracy. Traditionally, rights have been classified or categorized under two categories. One we say as civil and political right, other we say as a socio-economic rights. And it is this classification which considered to be a reason for introducing different enforcement mechanism. For civil and political rights, it has been said that it is to be enforced through court of law. For other, it has been said that it is non-justiciable and therefore it cannot be. Now, this understanding of treating them as two distinct compartments has already been adequately addressed. It has been in scholarly writing, it has been in constitutional document, it has been truly established that this compartmentalization approach is not very appropriate. And in fact, Constitution of India is a good example of that. To substantiate, I would just like to highlight two examples, which is there in the part 3, that how in the matter of civil liberty, the framers of the Constitution decided not to only rely upon the judiciary to give effect to the libertarian values. Because when you read or when you try to understand that what the civil liberty is all about, it takes us to the point of the protection of rights, the very value which ensures autonomy to individual. But then it is well established that autonomy alone is not enough to lead a dignified life. Along with autonomy, well-being is equally important. And it is this facet of well-being which is being conceptualized under Part 4 of the Constitution. I would put it in this way. So look at the way civil liberties have been incorporated. And the role of the parliament is being clearly identified. I bring in here Article 17, which talks about abolition of untouchability. It has been categorically said that Parliament shall have a responsibility to make a law. And look at the framer says, make a law and ensure that it is law which declares this inhuman practice as an offense. So option was also not given. So civil liberties are being protected also through parliamentary institutions, also through parliamentary process. Same is the case with Article 24. And why I'm saying so, why I'm highlighting on these provisions, just to establish that under the constitutional scheme, Parliament has been entrusted with a very defined responsibility, very, committed responsibility. And it is not only in relation to directive principles, which generally what we read when we look at Article 37 or 38, which says about the responsibility of the legislature or the executive. Even if you look at Part 3, what we observe that there is a non-negotiable obligation on the part of the parliament to do everything what is needed to guarantee civil liberty. In fact, to substantiate this, I would also like to mention, when you look at the provisions which are there under the equality clause, you find that the maximum number of provisions are there in equality clause. You have 14, 15, 16, 17, 18. 5 provisions are there, which in a way communicate that for guaranteeing equality, enough mandate is there with the parliament. And the interference by the judiciary shall be minimal. I'm not getting into the debate that how do we see the interference by the judiciary, either in the approach of test of classification or test of reasonableness. I'm not getting, that's a different debate altogether. But then, just to substantiate my point that how the role of the parliament has been conceived in addressing civil liberty. And this is what is in Part 3, which has been made justiciable. Now, let me take you to Part 4 of the Constitution and look at the way the framers interested an obligation on the parliament. It is clearly said in 37, it shall be the duty of the state to apply these principles in making laws. And then when you look at the expressions which are used in different articles of the directive principle, this element of duty has been amplified. It says, for example, look at the language of Article 43, 44, 45, 48. It says that a state shall endeavor. Article 47 says there shall be primary duty. 38 talks about striving. 39 talks about in particular direction. 41 again talks about to secure. 43A, Article 50 talks about shall take necessary steps. 49 uses the expression obligation. Now, what these expressions in different articles in Part 4 symbolizes? To me, it symbolizes a well-defined obligation, responsibility on the Parliament. And in fact, it is the trust on the Parliament which made the framers to make Part 4 non-justiciable, I would say so. Because there was a deliberation on it, that why not to make it also justiciable. And then there was a consensus decision taken that if you make it justiciable, there is a possibility where individual rights may take over to communitarian interest. And when I say communitarian interest, please do take note of this understanding that communitarian interest, I would put it as a socio-economic rights. Because it is not only freedom from fear, but also freedom from want. The famous quote of Roosevelt. The very premise on which the United Nations document based its foundation, wherein both freedom from fear and freedom from want was institutionalized. And that perhaps is the case even with the Indian Constitution. Much before the deliberation, the United Nations on Socioeconomic Rights, in 1931, in Karachi Resolution of Congress, a Bill of Rights was presented where you had a detailed elaboration on socioeconomic rights. So why I am highlighting this? Just to establish this point, that to us, civil liberty need not be seen only in relation to individual, and it need not be only confined to first generation rights, because freedom of speech is equally important, and freedom from hunger is also important. And look at the kind of experiment done by the framers. They have guaranteed freedom of speech, but then they have also clearly spelled out the grounds on which this freedom can be restricted. And therefore our experiment is different. And libertarian value was incorporated under 1901. If I take the kind of philosophical understanding of liberty, what has been given by Lasky and all, it has been incorporated under 1901. But then a new experiment was done. What is new experiment? Along with freedom guaranteed, along with libertarian value, which has been incorporated in the Constitution, they have also said if the state is having a justifiable reason to take away, that action of the state shall be constitutional. Look at the experiment done. So at no point of time in India, under the Indian Constitution, the other two institutions, legislature or executive, are being asked to not to work in furtherance of the libertarian values. That's what is the kind of distinctiveness, I would say. And look at it. It is this distinctiveness which justifies the incorporation of Article 31 capital A and 31 capital B in the Part 3 of the Constitution, where it says that if law is being made in furtherance of directive principle, let fundamental rights be not a reason to assail the constitutionality. This is what? This is to give a new meaning to libertarian concept, I would say. That yes, it is needed to it is incumbent upon the state to protect rights of individual. But then in that process, it is also to be seen that what all is needed to make that rights meaningful. When I say what all is needed to make the rights meaningful, I am referring to socioeconomic entitlement. That is also to be taken note of. And in that regard, I look at the judicial approach in 4 different categories, 4 different phases. One, I would say, is about a period when we mistakenly adopted the Western idea of civil liberty. When the court started looking at the language of fundamental rights in a very religious way and said that anything which has been done in furtherance of directive principle would be declared as unconstitutional. No, there's a famous case of Champakam Dore Raja. That's what resulted into the incorporation of Article 15.4. In fact, one of the main grounds for declaring the affirmative action unconstitutional was that it violates, and 46 cannot be given prominence because 46 is a part of directive principle. And why is it mistaken? I mean, a kind of misplaced understanding, because the very drafting of the Indian Constitution has Indian flavor into it, which we need to analyze, we need to acknowledge, and we need to internalize. Because apparently it appears that we have borrowed many provisions from the other constitutions. But then a finer line is that borrowing is just a reference. The way when we write a research article, we give a reference, but ideas are our own. So it's a reference, and nothing wrong in drawing references, nothing wrong in, referring to the material which is in front of you, but then it has its own flavor. So that's why I'm saying it's a misplaced one. Then look at it. When the court started acknowledging that fundamental rights can very well be given a sort of hands-on treatment when the ideals of directive principle is being considered by the parliamentarians while making laws. For example, land reforms legislation getting validated in the name of public purpose, where right to property was considered, but then still it was said that no, for establishing egalitarian society, we need to look at the goals which are there in directive principles. Looking at equality clause, looking at property clause, looking at freedom of speech and expression alone would not be sufficient. The third phase is a very interesting phase, I would say. And what is that phase? That phase where the court validates the parliamentary legislation where rights are being compromised and validating it on the ground that it is advancing the cause of socioeconomic entitlements. And in this regard, one case which comes to my mind, which I generally highlight very prominently, is Chandra Bhavan case. Validity of Minimum Wages Act, 1948. Look at the way parliamentarians were committed to value of civil liberty. 1948, right after independence, they enacted a law to ensure that every worker in this country should get a wage which is essential to lead a decent life. And therefore, I would say that let us not doubt the intent of the parliament as an institution. I mean, obviously, you can always say, sir, institution cannot have an intent. But then I'm talking about in a philosophical sense. 48, they decided to come up with a law which shall guarantee minimum wage. And that time, obviously, our GDP was not what we are today. But then it was a commitment. When law was enacted, the traders went to the court and said, we have a right to carry on trade under Article 19(1)(g). How can you come up with a law which shall compel us to pay a defined pay? And it is all about freedom of contract. Let the contractor pay some amount, let the worker, agree to take that amount. Why state is coming in between? What role state has? Why parliament is making a law on this subject? It is all about agreement between the employer and the employee. The court looked into the language of 43. Court said no. 19(1)(g) can very well be reasonably restricted, because any life which is inhuman is not worth living. And look at the way I would put it. This idea of civil liberty is being advanced with the support of directive principle, which is primarily a responsibility of the parliament, language of 37, to keep in mind while making laws. So primarily the state responsibility and primarily the parliament's responsibility. And then we are very well aware that in good number of cases, the court has invoked directive principles to validate parliamentary legislation, which in a way compromised the rights guaranteed under Part 3. And this is what is the uniqueness of, distinctiveness of the Indian Constitution, I would put it. That we have referred to others' constitution, we have not borrowed. This is what is the Indianness, what I'm referring to. And the last phase, I would say, is the phase where the court started acknowledging the significance of newer rights, or started acknowledging the status of socio-economic rights at par with civil and political rights. When I say newer rights, I'm talking about, let's say right to access internet and right to social security. Then when you talk about treating at par, right to health, right to education. Now education obviously is a fundamental right. This is the fourth phase, I would put it, where court has expanded the meaning of life or liberty under Article 21 as given entirely a new I would say a new pattern to the readings of right under the Indian Constitution. I don't know whether it was envisaged even by the framers that one day Article 21 will become such a celebrated provision that you name a right and you'd find it there. Now to conclude, now there where I see parliamentary democracy playing a very influential role in fulfilling the libertarian goal. What is it? That acknowledging new right or giving a status at par with other rights is a welcome step, but that is not enough. If rights are being acknowledged through a judicial pronouncement, there is no guarantee that this is going to get realized, because some of the rights require resources for implementation. If the court keeps on telling that right to health is a fundamental right, unless and until resources are allocated, that right has no value. I mean, way back, I believe in 80s or so, or no, sorry, 90s, mid-90s, Paschim Bang Mazdoor Khed, court has said that time about right to healthcare. And we know very well in last 2 years how the whole mankind has suffered because of the lack of the machineries in place for the realization of this right. So this takes me to this observation that it is true that judiciary plays a significant role in nurturing the rights by acknowledging it, because that has its own value. In fact, when you look into the debate on right to education, you would find that some literature indicates that had the court not said it in Mohini Jain, perhaps it would not have become fundamental rights. There's another way of looking at it, is that when already we had 45, where was the need of making it as a fundamental right? Are we in a way acknowledging that directive principles are inferior? But that's a separate debate altogether. Now, judiciary is acknowledging, and that is a welcome step. But that is not enough. Why it is not enough? Because that acknowledgement is not good enough for realization of rights. For realization, you need resources. And who has the competence to allocate resources is the parliament. And there where parliamentary democracy comes into play. And if you look at the debates which generally takes place in the parliament on these issues, you'd find it very enriching. What is needed is that this parliamentary reports, this committee reports of the ministries, they must be made non-compromisable evidences in the court of law, and through that, state should be made accountable. When the lawyers, they submit volumes after volumes to establish their point, I would say when it comes to socioeconomic rights, this parliamentary reports are to be accepted as an evidence without any contest. There shall be no objection to it. And it is needed that when this kind of litigation go to the court must look into those reports where the parliament is talking about allocation of resources, the parliament is talking about, commitment towards socioeconomic entitlements, and considering that the court passes the necessary direction. I'll give you one example of which has been decided by Delhi High Court. It's Mohammed Minor versus NCT Delhi High Court. It's a case related to, again, right to health. Son of a rickshaw puller, suffering from a life-threatening disease, approaching Delhi High Court. Delhi government said, see, we had a plan in place and we had given the financial assistance to the patient. Court said, right to health is something which is not dependent upon what allocation you have done. It is something which is non-negotiable. Give the financial assistance whatever is needed. Now look at it. It has its own danger. Why? Because with 1.25 pollution, population, court cannot keep on instructing the government like this. And therefore, what is needed is that minimum core of every rights need to be identified. Minimum core. And not very difficult to identify. After all, Minimum Wages Act is an example of minimum core only. Why 200 rupees? There is scientific basis behind it. Why 300 rupees? There is scientific basis behind it, which gets revised, on a very periodical basis. So let there be a minimum core identified. And let the justiciability happen on the basis of that minimum core. Now look at it. Who shall define minimum core? Is the parliament, because parliament knows the resources. Parliament allocates the resources. Let the minimum core be defined. Whether minimum core is being spent or not, or whether it has been reasonably allocated or not, judiciary comes into picture. I am forgetting the name of the case. It's Uttarakhand judgment, where the court has given a kind of sermonization to the Uttarakhand government that don't buy new cars for your ministers. First, ensure that necessary infrastructure is there in the school. I believe it was judgment of 2017 or 18, or it's one in order. This is about court, in a way, tacitly telling that what shall be the priority of allocation of resources. And this is what is needed for strengthening liberty in this country. To conclude, I would say it is not about assailing the role of the parliament. It is not about being susceptible about the parliamentary approaches. It is all about revisiting the task assigned and to ensure that the performance of the parliament as an institution is to be measured on this very benchmarking, that what is commitment, what is the action, and this benchmarking can very well be examined, tested in the court of law. So let court of law also not jump the gun. Let them not give a false hope to Indians that if you file a petition under Article 32 and if there is an acknowledgement of a right that serves as panacea of all ills, it is more of a kind of hand-holding approach which is needed. And therefore, parliamentary democracy has a role to play, and I would say it has been playing the role. It has been playing the role in strengthening the preambular concept which has been given in the Indian Constitution, that liberty, equality, and fraternity. So let us read the value, the concept, the idea of civil liberty, the way it has been institutionalized in the Indian Constitution, I would say. Thank you very much.
Thank you so much, sir, for such an energetic and thought-provoking address to the. I hope the audience have really enjoyed it and they will take it home, the idea you have just suggested. Thank you so much, sir. We have Professor Devinder Singh is our chief guest for today's event. Presently, he is the chairperson, Department of Laws, Punjab University, Chandigarh. Professor Singh has having the teaching and research experience of more than 21 years in the field of law. His area of expertise are constitutional law, election law, family law, human rights, and administrative law. He held various prestigious positions as an administrator. To name a few, he is member Senate to Punjab University, Chandigarh, Secretary to Vice Chancellor, Punjab University, Chandigarh, Legal Counsel, Punjab University, Chandigarh, Dean School of Law, Maharaja Agrasen University, Baddi, Member University Court, Central University, Haryana, Mahendragarh. He has guided more than 100 students in the PhD and LLM programs. He has more than 50 publications to his credit. He has authored the book on Article 370 and Union Territory of Jammu and Kashmir and Ladakh. Child Labor and Right to Education is the another book. Then he has authored one book on human rights, women, and law. He has more than 33 research articles published in various journals of national and international repute. He has invited as a guest speaker, resource person, panelist in more than 100 international and national conferences. He's the member of editorial board of various reputed journals, and the list is endless. So without wasting much time, I would like to invite Professor Devinder Singh, the chief guest for today's event, to address the House. Professor Devinder Singh. Over to you, sir. Sir, please unmute your mic.
Very good morning. Revered Vice Chancellor, Bhagat Phool Singh University, the Registrar, keynote speaker of the day, Professor Uday Shankarji, chairpersons of the subsequent sessions, Professor Deepak, Professor Jaswant, and professors from Kurukshetra and professor from Kerala, which has been introduced earlier. Coordinator of the seminar, Dr. Paban and Dr. Alka, who has compelled all of us to be the part of the seminar, come but may. That seminar is being held on civil liberties, but we don't have a right to say no. We have right to say yes only to be a part of seminar. Anyway, we have been part of Bhagat Phool Singh University earlier. We have few academic exchanges there. So it is always good to interact with the faculty at this. So thank you very much, Dr. Alka. You have given opportunity to interact with the colleagues in the Bhagat Pur Singh University. Since 10 o'clock, thought-provoking discourse are going on, and while listening all those, I have reached a moment where I see that enough for the inaugural session. It is a time of 2020, and in the 2020, one batsman is enough. Still, if I have been roped in, then I will spend some time on the pitch if the overs are left out. The title is beautiful. It says Civil Liberties in the Parliamentary Democracy. It's a global perspective, maybe referring to India. And when we say it is civil liberties, then we understand this, that let it be the laissez-faire. Bill of Right in USA, first Bill of Right in USA simply says that government is prohibited from interfering the lives of citizens. That is what we have procured. And so on in Britain, so on in India. But I hope the message of this seminar was civil liberties and civil rights, as keeping in view the Indian context, because these civil liberties has been translated into fundamental rights. And these all fundamental rights, along with the directive principles and constitutional developments. I was thinking that the issue was big, but it was so nicely and beautifully taken into one fold by Professor Uday Shankarji, has explained the provisions of the Constitution pertaining to the civil liberties, its constitutional functioning since 1950 until date. If we see Bill of Rights and then our democracy, parliamentary democracy, has grown up in the shadow of British Parliament. In Britain, the civil liberties has its own struggle. They have struggled for the right to vote. In Britain, they have struggled to become the member of the trade unions. If so is the struggle for the civil liberties, and our constitution is a reflection of their parliamentary democracy, we have learned a lot and converted these civil liberties into the civil rights as well. We promised our citizens all these rights, which were known as a struggle for civil liberties, non-interference by the state, and all that, defying even the jural postulates of the Hofflet when he says the civil liberties, in the civil liberties area, the government or the state need not to interfere into. Our constitution stands apart for granting these civil liberties and civil rights to all citizens. And that constitution is a distinct constitution, is a distinct composition of the country. That is why we stand apart from others for many issues. For the purpose of parliamentary democracy, I like two things about the parliamentary democracy. No doubt democracy is the best form of governance, but the parliamentary democracy, I see two outstanding features of the parliamentary democracy. One is the collective decision making. Decisions are always taken collectively. It is not one-man show. And the other is periodic elections in Indian democracy, that after 5 years, whatever you have done, but you have to go to the people. It is periodic mandate. It is not permanent mandate. If mandate is permanent, we can see what is happening in Russia today, because the mandate is permanent. We have a periodic mandate. So this makes the parliamentary democracy a beautiful thing to live in. So these are complementary and supplementary, or rather supporting parliamentary democracy is the most fruitful environment for the civil liberties. We have just to see that how we have gone through in the past years, whether we have accomplished certain goals, whether our path which we have taken is correct or not. And there are certain things which we need to address. If I start with the ending note of Professor Uday Shankar regarding health schemes, regarding employment, and regarding many things, which are because the third component of the seminar is the issues and challenges being faced recently. So, government proclaims, takes pride. During the pandemic, government is feeding 80 crore people. If 80 crore people are to be fed by the government after 70 years of the republic, is it a thing to celebrate? Government is planning that we are giving health scheme to 60 crore people, and it will change the whole scenario. What we have done for since 1950? Yes, the question of resources was there, all there. Resources are always deficient. We were never handful of resources to spend on these things. The education, we have given fundamental right to education. The moment this right to education is being given, or in post Unni Krishnan or Krishna Mohini case, things are commercialized. On one hand, we are talking about the socialistic pattern, and on the other hand, we are talking about the capital things, that the things are now commercialized. And in this background, socialistic background, civil liberties where the government is expected not to interfere. If we see the principles of good governance which are given in part 4, which have been adequately elaborated, these are the principles of good governance. I am not going by the principles which are given by the World Bank or United Nations programs. They are apart. One of the principles says, apart from resources, that the governance has to be strategic. It is not a simple governance based upon accountability, transparency, participatory, and all that. It is a governance which has to be strategic. Country like ours, if government do something for a particular section of the society, definitely the other feels jealous of that. If government takes some decision that yes, we are going to do something for the employees, yes, do for employees, but what is to be done to the unemployed? That is also a big issue. Strategic governance is a part here. And what we see, the conflict in the society, apart from resources, that is most important component. But still, we see that there are many sections in the society, they are competing with each other. One such example comes to my mind is Ambedkar-Gandhi debate on the issue. Gandhi was an ardent supporter of Panchayati Raj. He always wanted that. Empower the panchayats. Self-rule means panchayat. But Baba Sahib Ambedkar was opposite. This is the level of debate in India. In this background, the constitution was made. Healthy debates took place. Baba Sahib was of the opinion that if panchayats are empowered, then what will happen? And here comes the concept of civil liberties. We can't leave the people laissez-faire, that whatever you want to do, you do. Baba Saheb was against this. If we leave this, I am addressing this conference though virtually, but I know Sonipat and other we are living in the lands of cops. If we allow the people to live their own terms, live their king-size life at their own, it is liberty. What will the result? Baba Saheb Ambedkar visualized it and said, no, Panchayati Raj is to be the directive principle of the state policy. It is to be cautiously taken. We can't give directly the powers of the Panchayat. And we all, those who are grown up, crossed 50, can see what was used to be the composition of the Panchayat before this Panchayati Raj system, 73rd and 74th Amendment. We can see that Sarpanch means what? Here, governance has to be strategic. So, Gandhi-Ambedkar debate took place, and after 40 years of the Republic, Parliament deliberated it and gave Panchayati Raj institution well inclusive, all inclusive. Take your governance, take your empowerment. Country belongs to you, power belongs to you. This is the beauty of this country. This has to be done. That is why I say directive principles are supreme, even which are floated by World Bank or United Nations. That we have to treat cautiously, and we have to have the inclusive growth. And now we see the empowerment of people in Panchayat. You can name any section of the society. Within 20 years of its working, you see every section of the society has a sarpanch. And language. We just celebrated a Mother Tongue Day. That is why I am taking language first. It is fresh in your mind. Constitution says official language, Hindi and English, along with regional language. It means equally important is English, Hindi, and one regional language. That was the constitutional scheme. Education is to be given, at least primary education is to be given in mother tongue. How we have implemented that? Because constitution was given to us. Baba Saheb Ambedkar, on completing the constitution, has said that even bad constitution can be a successful constitution if it goes to the successful people, it goes to the honest people. The best of the constitution may be ruined if it goes to the hands which doesn't know its value. It was a speech full of anguish with Ambedkar. And what we see, language becomes a divisive factor in India. Unhealthy debate between Hindi, which is official language, not national language, not mother tongue of the people, those who have mother tongue, has been put to the states. I'm living in Punjab, which is a minority state. They're always afraid of Hindi, that Hindi shall be given to us as a language. Constitution never thought like this. It was official language, Hindi and English. It was thought that Britishers has gone, and it was something obvious that Hindi will take over in next 15 years over English. English has to stay. Let it stay. This is an open country. It's a free country. Everybody can stay here. So language can also stay. Nobody was asked. But Hindi was poised in such a manner. I don't know it was right strategy or wrong strategy. But Hindi started competing with regional languages, and English flourished like anything. And it was expected within 15 years, Hindi language will replace English language. It could not replace English, but it has become enemy of all other languages. It is a recent challenge. National education policy has come in 2020, and the first reaction of the states was that you can't give Hindi as a compulsory language to us without reading its draft of 500 pages, without reading its final draft of 60 pages. States started reacting. It talks, national education policy talks about mother tongue, but it is national, and we understand it's a righteous government at the center. So immediately all states reacted that we will not take Hindi as such. So it was the result of strategic fixing, or the Hindi is being placed as such over the regional languages. It was not expected that it has to happen, and we continue. The problem has not come to an end, but I wish all that national education policy is in the right perspective. It gives equal importance to all languages. All languages means it is mother tongue. May now be started in this perspective and start the competitions of languages as early as possible to grow in the right direction and achieve the constitutional goal, that is official language, regional language, and mother tongue. It was all clear. It was not one language versus other language. Basic structure theory, Minerva Mills case, fundamental rights and directive principles are written in the Constitution as such. I'm sitting, I think, on the highest platform of constitutional students, Professor Uday Shankar, Professor Deepak. I know them personally. They have been studying in Constitution. And the way Dr. Pavan spoke today, so I guess I have not opportunity to listen him earlier, but he's also in Constitution. Supreme Court need 30 years up to Minerva Mills case that fundamental rights and directive principles are complementary and supplementary to each other. Was it so complex and so difficult proposition to understand? Things started moving from the Kameshwar Singh's case, where I remember when Patna High Court gave the judgment and it was challenged before the Supreme Court, and government was about to bring in the first amendment to the Constitution. In Rajya Sabha, Pandit Jawaharlal Nehru spoke in anger that the Constitution created two houses of the Parliament, that is Rajya Sabha and Lok Sabha. Courts are trying to be the third house, which is not there. We want land reforms, and it would be there. We know this ninth schedule was created, and we all understand, as is constitutional law students, that ninth schedule is full only on the agrarian reforms. But in reality, what we have seen on the ground, what changes we have done on the ground. Property right to property as a fundamental right has been reduced to a constitutional right, a legal right which we say can be restrained. My understanding of Constitution, my understanding of property laws, my understanding of civil liberties says, can anybody stop me from buying property? Can anything specific or capping be done? We know the people in this country. It is a subject of economics that only 10% people has 90% resources. They can make their house where chopper can land. Can they be stopped from doing so? Can they be stopped from acquiring property? Constitutionally, we are correct that fundamental right to property as a fundamental right has been reduced to a legal right. We can put on caps on that. We can put on restraint, constraint, and many things on that. Are we able to do this? Answer is, for all of us, I guess, practically no. Yes, if it comes a 15 marks question in the examination. We have a lot of material to do, right from 31A, B, arrest while C, and then D, and 9th schedule. We can write a very good essay on that and question on that. But if we go for the empirical at the LLM level and PhD level, what we see on the ground level, no difference. If you have resources, you can continue to buy property. It is like fundamental right. The thing which was given to us by Kameshwar Singh ji, that this is a country of landholders. You can't take our land. Nehru ji tried, Shrimati Gandhi tried, and presently we have seen, this is also recent issue, civil liberties. This is our right. This is our domain. Government cannot make laws for us. Maybe controversial for many because this is a land of farmers where I am addressing, but this is reality. This is our land. This is our crops. You can't decide on us. This is a legacy, my dear friends. If you see, Nehru ji tried it, can't do land reforms. Shrimati Gandhi tried, can't do it. And when you see the law, Article 31A, 31B, and 31D, give compensation, land can be acquired. Can it be done? No, it can't be done. In 2015, government came, brought an amendment to the land acquisition. First ordinance, second ordinance, and third time it was taken back. It is civil liberty. We are powerful enough. You can't do it here. Civil liberty is to be understood from another perspective. And that is the right perspective. Don't interfere in our lives. Governments also try to interfere. We have seen the times of emergency, where there was invasion and interference to the rights of citizens. Constitution is so great. Our constitution is so sustainable. Credit goes to Supreme Court for putting the basic structure theory that you can't change it. You can't go away from the basics. Somebody mentioned morning Justice Hansraj Khanna. On the lighter side, or just to take away you from this serious discussion, I was delivering a lecture in Hisar HRDC. It was a lecture on fundamental rights, and it was a lecture to non-law teachers. So I have to address like that only. Now, non-law teachers, they are teachers, they understand everything, but they understand from newspapers and magazines and other things. So they asked a very academic question or a very popular question from me, that who is the best Chief Justice yet? Who is best Chief Justice ever yet? I am connecting it to today's event. Automatically I said, I don't know who is the best, but I know the best who could not become Chief Justice, and that was Justice Hansraj Khanna. We know the whole background. We know the whole background of emergency. We know the whole background, not politically, but legally. A dissenting judgment has the power to become on the main course and to be implemented as such. It was the power of the dissenting judgment. It was the power of a judge. We all wish he could have been the Chief Justice of this country. He has written a book, Justice Hansraj Khanna written a book, Neither Roses Nor Thorns. I'm just reading a line from that. He said that my friends in bar, in judiciary, in social arena, tried to convince me that you become Chief Justice of India, then you shall be head of one of the organ of the government, that is judiciary. You will be in a better position to serve the people of this country. This is a land of Swami Vivekananda. Swami Vivekananda says, you can't win yourself. If you can win over yourself, all things is done. Justice Hansraj Khanna writes. Justice Hansraj Khanna writes in half-line sentence, I could not convince myself the suggestion, the advice given to me by my friends in bar, judiciary, and social arena, journalists, all that, I could not convince my. So high is the conviction. Had we implemented this constitution with that conviction, our results would have been different. Constitution is a powerful document, social welfare document, welcomed by all. We were talking about elections. I have my own perspective. I think beyond the things which is discussed by the Law Commission of India and all that. When elections comes to my mind, then we say this is a criminalization of politics, people are criminal and all that. I see it from another perspective. I hope you also see from that perspective. And I see only from that perspective. Criminal cases and all that, it is always there. But the capitalist thing, I am in Punjab. Punjab have just completed the elections. Election Commission of India says, which is a constitutional body, that candidate who contests the election can spend 40 lakhs, can spend up to 40 lakhs. This is what we have achieved, my dear friends, a country which is socialistic in nature. Meaning thereby, minimum expenses to contest an MLA from a constituency, then expenses which is prescribed by Election Commission of India, then you can spend 40 lakhs. It means in saving account, you should have 40 lakhs. Because that is the minimum expenses you have to meet on your traveling, on your sponsoring, and on your everything. That is the minimum expenses, that maximum expenses rather, you have to spend. It can be 5 lakhs less, so it is still 35. You have to spend 30 in your traveling and all that during your campaign for 16 or 14 days, whatever is there. The thing which we celebrate, that government comes after 5 years. Everybody can contest elections. It's a political democracy. At least political rights we have. Ask yourself. It is an inaugural session. Here, keynote speaker or me or anybody else cannot be questioned because this is an inaugural session. But you have subsequent sessions. Ask yourself, discuss. Who is eligible to contest the election? How many people are eligible to contest the election? And also ask the student at the LLM level, whenever election takes place, people who spend minimum, see their vote level also. How many votes they have taken. This is irony, my dear friends, that we have taken the constitution to the other side. One side says secularism, and on the other side, you increase religious input. The better is you accept that country can be secular, nobody's against secularism, but people are religious. People are religious in this country. They have the minimum fundamental freedoms in the name of religion. You can't interfere there. Then another divisive factor where the civil liberties does matter, like cops, it is another thing. It was the inclusive growth, the egalitarian society of which we are talking since morning. Equality among all. It is not the equality among the equals. Everybody has to equal. We know that there are downtrodden. There are weaker sections in the society. That is what I say, that this is India, this is Bharat. It is a composition of many things. Constitution Assembly debated and said that as a fundamental right to employment, it has to be class. It can't be caste. Caste is a divisive factor. If we take as it is, then we will not grow. Country may be divided on the basis of this. Communities are divided. So for inclusive growth of everyone, we have to use the word class. And where we have landed? In the First Amendment, we know, and it is referred to by the keynote speaker as well, when First Amendment to the Constitution was done, then we added Article 15, subclause 4, said socially, educationally backward classes and scheduled caste and scheduled tribe. We took some time to identify other castes, socially and educationally backward classes, and by the time we started with 2, and then immediately question was asked that it was class, and Constitution says that it is socially, educationally backward class, including SC and ST. It becomes the part of the Constitution, my dear friends. Now we are asking from where the caste has come. Caste has come from the First Amendment. Things which could not be done in the Constitutional Assembly has been done through the First Amendment, and see what has happened to it. Those who are getting the reservation since last 70 years are not happy. Those who are not getting it, they are jealous. Meaning thereby, we have an approach, inclusive approach. Everyone has to be there, and very nicely. I always refer to the people in the Constituent Assembly. They were wiser. They may not be wisest, but they were wiser to us. And they have used class. Class means if we have different type of schools, we are talking of right to education. If we have different type of schools for education, take the government schools. Government schools are almost similar in all over India. Delhi claims to be ahead of many states, but we take it as that they are also as comparison to their own schools. Parents who are sending their children to the government schools, to my mind, they are a class. Judging them by caste is a dishonesty. If they are sending their children to the school, and in the school, these are the schemes of the government. If in the school funds comes, that fund is being there for the SC students to go on trip, travel, education trip and all that. Why not for others? It's a social classification, my dear friends. People are to be known by class. Better we start earlier, and for the purpose of seminar. This is a recent problem also. It was a problem 1950. It is a problem now. Better we start with class. Everybody is a class. We are teachers, so we are teachers. Somebody is the owner of land by classification. They have big land, they are big landholders, they are mediocres, they are small, and they are landless. This is classification, they are class. Early we start accepting these constitutional goals which we missed out. Early we would be achieving the nice promises given to us in the preamble. We all students of constitutional law read the preamble. It is utopian. It is Ram Rajya. And if somebody takes some framer of the constitution, or for that matter, Pandit Jawaharlal Nehru, takes rebirth in India, because this is a land of religion, we believe in rebirth. And he recollects his assembly days and see the constitution and his preamble, which was drafted by him only. Let's see the promises which was done in the preamble, and the direction which we have chosen, and what we have achieved. There are many things. I can go on and on, but I know that you don't want to listen me anymore. And I told you that the left of overs I have to pitch in. So I think this is 20 over quota is full here. And the last thing which I can submit to the organizer and the subsequent chairpersons, which I can see on the screen, that let us concentrate on solutions. Issues and challenges are for this inaugural session. We have highlighted the problems. Let us come to the solutions. We have to change this mindset that the problems, I can count more problems, so I am better author. Somebody can count more problems, he is or she is Magsaysay awardee. And somebody counts many problems, he is Nobel awardee. Things has to start with us. We are the leaders in academics. We have to discipline ourselves, our disciples. The way, solution-oriented education. What is the solution? Yes, we are living in the land of khap. We are living in the land of big landholders, but we have to give rights to all. Constitutional dream was not to empower the already empowered, Kameshwar Singh's theory. Constitutional dream was to empower everyone. Our approach has to be solution oriented. Otherwise, I am delivering lecture here. You are sitting at your own places. We count 10 problems by the evening, that these are the 10 problems highlighted in the inaugural session and subsequent sessions. And we'll go for a cup of tea, maybe alone or with somebody else. And the tea seller भी आजकल एक रेफरेंस है. चाय की दुकान पे बैठिए, उसको भी वही प्रॉब्लम पता है. The person knows the same problems. Person who is selling tea or running canteen in your college or your university knows the problem which we are discussing. He knows it. He reads the newspaper every day. He's aware of the problem. So these kind of seminars and conferences can make difference, can bring a paradigm shift in academics. All students are leaders. They are sitting as a learner, but tomorrow they are leaders in society because they are educated in higher education. So it is expected that in the subsequent sessions, if a problem is discussed, that will be solution altogether. Otherwise, my experience is 10 years back when I started taking LLM classes, and when you start taking LLM classes, you have lot of thing in your mind that now you are taking LLM classes, so you have to spend 2 hours in LLM class. So you have to do many things. Spend 3-4 months in the class, and subsequently when started taking their seminars, then one of the student has made very good presentation on Dory problem. Asked a question. Professor Nishtha Jaswal was also sitting with, because he was senior teacher with us here in the Department of Law. I asked a question from the student. Your presentation is very good. You have very good literature here. Please tell me 2 solutions, how this problem can be eradicated from the Indian society. कहती सर ऐसी तो मैंने कोई किताब ही नहीं पढ़ी, ये तो प्रॉब्लम खत्म ही नहीं हो सकती. It is going to stay. It is going to stay. मैं सर इतनी किताबें पढ़ी, ऐसी कोई किताब ही नहीं पढ़ी मैंने जिसमें ये लिखा हो कि ये प्रॉब्लम खत्म हो सकती है. Let us introduce this kind of material, this kind of space in the minds of our researchers. Only then we can see the change. Otherwise, in the inaugural session, the problem were highlighted in 1950 and problem in 2022. They are recent, and nation was newly born, and nation has traveled 70 years. We are standing at the same place. Things has to change, my dear friends. With these few words, you have heard me, and what can I say? If you can't rate me as such, I can say I am always a poor student of law. I do not quote Supreme Court. I do not quote anything. I have always a thinking out of box, because I consider I am studying constitution as a student since last 25 years. And it is a pity even the law students do not know the constitution. Dr. Alka has just mentioned that I have authored a book on 370. No author has taught us 370 in their books. We claim them as author, all big authors. But the students of law, we have also done LLB, but no author has taught us 370. Not in syllabus, but in books. They do not cover 370 apart from the bare language. We can't do this kind of things. In academics, we have to bring a change. And today, the only request I can make to the subsequent chairpersons of session and Dr. Alka, Dr. Paban, that they will concentrate on the solution part. We have many problems. Everybody can count problems, but we have to go towards the solution. And I'm sure that you will do that. Once again, I'm thankful to Dr. Alka. I think this long address I have given after 2 years, and when I promised that I will come, I was sure that I will not be coming, but through her messages and connectivity for I think 20 days, I'm here. So it is for her. Credit goes to her that I am here. So I hope she will do wonders through this seminars. And if the proceedings are published, whatever I have spoken, I will give in writing as well. Thank you very much, everyone, and best of luck to you for the rest of the day. Thank you very much.
Thank you so much, sir, for such a lively and inspiring deliberation. I think it's like a crash course on fundamental aspects of constitutional law, and the participants are really wish to listen to you for the whole day. They are so encouraged and they are so enlightened through your deliberations. Thank you so much, sir. Now it's time for a vote of thanks. So much has been given to me. I have no time to ponder over that which has been denied. These words of Helen Keller explains the importance of gratitude in our life. On behalf of the organizing committee, it is my proud privilege to propose the vote of thanks on this August occasion. As we are proceeding towards the culmination of this introductory session, we feel very fortunate to experience the virtual presence of our distinguished chief guest, Professor Devinder Singh, Chairperson, Department of Laws, Punjab University, Chandigarh, who augmented us by sharing his thought-provoking deliberations akin to the concept of civil liberties. Sir has laid emphasis on the concept of fundamental rights and directive principles of state policy, constitutional functionaries, history of fundamental rights, and how this concept is imbibed in our constitution through the British provisions. We equally extend our heartfelt gratitude to Professor Uday Shankar, Registrar, Hidayatullah National Law University, Raipur, though Sir has to leave the meeting due to some official commitments, but we are very grateful to him that very generously he accepted our invitation to be with us on this forum today. Sir has enlightened us with his immense learning. Sir has given a wonderful insight to the concept of fundamental rights within the constitutional framework. He described the interwoven concept of fundamental rights and directive principles of state policy very beautifully. He further spoke about the role of Parliament to ensure civil liberty that is very significant in the contemporary scenario. We express our heartfelt gratitude to our resource persons for the session. We are very grateful to Dr. Deepak Kumar Srivastava, Dr. Jaswant Saini, Dr. Naseema PK, Dr. Manjinder Guliani for their gracious presence for the seminar as the resource person. We are equally grateful to Dr. Dipali to chair the session. It's a personal moment of joy for me as I'm sharing this platform with one of my teacher, Dr. Manjinder Guliani. My heartfelt gratitude to all the resource persons again. We keep in record our indebtedness to Professor Vijay Nehra, Dean Department of Law, BPS.MAHILA, KHANPUR, KALAN, for his support and motivation. We express our sincere gratitude to our in charge, Dr. Rajesh Hooda, Program Director, for her untiring efforts, perseverance, dedication, and strong willpower, not only for this event, but for the whole department, the functioning of the department. She's very keen to this. She's the real motivational force for the team members. We sincerely hope to have her support and guidance for our future academic endeavors as well. We express our gratefulness for our worthy registrar for her support and guidance. Our sincere thanks to Dr. Pawan Kumar, Senior Faculty Member, Department of Laws, BPS.MV, and coordinator of the event, who visualized that this significant issue should be discussed and deliberated upon. We owe our sincere thanks to the members of the organizing committee, Dr. Annu, Dr. Durgesh, and Dr. Dheeraj, for their organizational skill, commitment, endurance, and exceptional cooperation. Without them, this preparation cannot be made for the event. We are thankful to the faculty members, non-teaching staff, and the technical team for their support and cooperation. My special thanks to the dignitaries in the audience who spent their valuable time with us. Last but not the least, we are very grateful to the renowned and informative audience and participants for their participation. I hope we are going to have a wonderful day ahead. We solicit your continued support to march forward in the quest for knowledge. Thank you so much. Now there is a break from 12:10 to 12:30, and at 12:30 we'll start with our technical sessions. Thank you so much for your benign presence. Thanks to one and all present here. Now we can proceed for the break. Sharp 2:30 we will join the session. Now the inaugural session is culminated. Participants may leave now.
Hello, madam. Madam, presentation when it will start, madam?
12:30, ma'am. The schedule is already posted on the WhatsApp group. Have you got it?
Yeah, madam, I have got it. I wanted to ask you whether there is a half an hour break right now or 20 minutes break right now?
Not half an hour, it's 20 minutes break.
20 minutes, yeah, 20 minutes, right. Okay, fine, madam.
We'll start the sessions.
Okay, madam, thank you. Madam, the presentation will be according to the schedule?
Yes, ma'am, it will be.
Okay, ma'am, thank you.
Dr. Alka, ma'am. So,
yes, ma'am. Yes, ma'am.
Hope I can leave right now and we'll join.
Yes, ma'am. You can leave, and you have to, join on the given link at 12:30. I think you are.
I would like to add just one sentence. The session was excellent. Congratulations to HOD, you and other conveners and other faculty members. It was really an eye-opening session, and the topic selected by the department is highly relevant. Congrats to all of you.
Thank you so much.
Thank you. Thank you, ma'am. Ma'am, my session is 2:30. Shall I join on 2:30?
Yes, ma'am.
Yes, okay. It is a PPT presentation is necessary. Whether it may be
no, that depends, ma'am. That depends.
Okay, it's not necessary, no, ma'am.
Yeah, no.
Just you have to deliberate. Okay.
Yeah.
Okay. Thank you so much. You have excellently coordinated also. Thank you so much. Have a nice day.
Hello, madam.
Yes, ma'am.
Madam, can you please tell me the time which is given to us to present the paper?
Ma'am, that will be decided in promptly in the sessions only. That depends upon the
Okay.
chairperson. They will.
Okay, man. Fine.
अलका मैडम नमस्कार। अलका मैम नमस्कार।
जी सर, नमस्कार सर। कैसे हैं सर?
Have you begun with this session?
No sir, we'll start from 12:30. उसके लिए अलग लिंक है मेरा सर, उसके लिए।
Okay. Thank you.
Hello. गूगल आईडी में डाल लेना, लॉगिन मार ले मैंने। हाँ जी मैम। ओके मैम। ओके मैम।